Okay, everyone, stay with me here, because what I'm about to walk you through isn't just news, it's unprecedented, and it could change how we understand the highest levels of power in this country. And this is your channel Exposed Power. 72 hours ago, a document surfaced that had been tightly sealed from public eyes for months. When it was finally partially declassified, the contents were shocking. At first glance, you might read it and think, this can't be real, because the implications are that serious. Here's the headline. The Supreme Court of the United States has issued what can only be called an ultimatum to former President Donald J. Trump. And yes, I mean ultimatum. This is not a polite suggestion. It's not a strongly worded recommendation. It's a command from the highest court in the land. Before we go any further, if you aren't subscribed yet, hit that button right now. Like this video. Share it. Because the information in this series is too critical to miss, and the algorithm only helps when you do. Now, let's talk about the document itself. This is a judicial order, signed by 6 justices. 6. And it's dated only 11 days ago, although it just became publicly visible because a procedural filing forced a redacted version onto the court docket. That's the only reason we even know it exists. And what it demands is explosive. Trump has been ordered to surrender materials that he and his lawyers have repeatedly claimed do not exist. The court has now confirmed, in writing, that these materials do exist, that he has access to them, and that failing to produce them is contempt of court. Here's the exact language, because every word matters. The respondent is hereby directed to produce all documents, recordings, and communications related to the matters specified in Subpoena 1-18A, no later than 14 days from the issuance of this order. Failure to comply will result in referral to the United States Marshal Service for enforcement, including custodial detention pending compliance. Pause for a moment and let that sink in. Custodial detention pending compliance. This is not a fine. This is not a civil penalty. This is jail. And the legal reasoning is critical. It's coercive, not punitive. That means detention continues until the materials are handed over. So what exactly are they demanding? Subpoena 118A was issued in connection with the January 6th investigation, but not about the events of that day themselves. It's about the 72 hours before the certification of the election. Specifically, it demands communications between Trump and several individuals whose names have been redacted in every public version of the documents. But from adjacent filings, we know at least 3 of them were senior military officials, 1 a sitting member of Congress, and 2 private citizens with no government role. Here's where it gets even more serious. The subpoena includes a declaration from a career archivist at the National Archives. This archivist confirms that certain recordings came to light in late 2024 during a routine security review. The recordings weren't logged normally. They were found on a standalone device in a mislabeled storage box. The archivist describes them as conversations of substantial legal and historical significance involving the former president and multiple unidentified parties discussing contingency measures in the event of certification proceedings. Let that sink in. They weren't talking about general politics. They were talking about the peaceful transfer of power itself. Trump's legal team claims the recordings don't exist. They say the device was inoperable, or that even if it existed, it would be privileged. The Supreme Court didn't buy any of it. Independent forensic analysis confirmed the recordings are real and intact, and privilege claims do not apply when there's a potential obstruction of constitutional processes. That's huge. This isn't speculation. This isn't rumor. This is the Supreme Court confirming there's evidence that could have a direct impact on how we understand what happened in January 2021. Now, if you're finding this valuable, comment below, share your thoughts, and make sure someone else sees this. This is moving fast, and it's history unfolding in real time. Let's pause and reflect on the timeline because that tells you just how seriously the government is taking this. The device was discovered in November 2024. The National Archives notified the DOJ in December. A grand jury convened in February, and subpoenas went out in April. Trump's lawyers fought at every level, from appeals courts to procedural delays. And now, after more than a year of litigation, the Supreme Court has issued this final order. What does that tell us? First, the court believes the recordings are real. Second, what's on them is critical to understanding the final days of that administration. And it gets worse. Another document appeared simultaneously, a confidential letter from the Solicitor General's office accidentally included in a public filing. This letter references a sealed hearing with all 9 justices. It confirms that Trump's legal team tried to request an emergency stay of the subpoena, claiming compliance would cause irreparable personal and political harm. The government's response? They provided testimony from witnesses with direct knowledge of the recordings, corroborated by metadata, texts, emails, and calendar entries. This isn't hearsay. This is evidence. Trump has known about these recordings, accessed them, and discussed them with advisors within the past year. That means he knew exactly what was on them. Now stop and consider this. Trump allegedly stated in front of witnesses that the recordings would be a problem if anyone actually heard them, and ordered them hidden. In legal terms, this is consciousness of guilt, a person aware something is wrong and taking deliberate steps to conceal it. And there's photographic evidence. A timestamped photo shows a digital recorder on a desk inside Mar-a-Lago, with the date and time verified by security logs and phone records. Trump's lawyers argue it's misleading, but the timing and corroboration make it damning. Alright, let's pick up where we left off. We've established that the Supreme Court has issued an extraordinary order, and that there's compelling evidence of recordings that former President Trump has knowingly withheld. But now we need to dig into what this actually means, both legally and politically. First, let's talk about the witnesses. The Solicitor General's letter confirms that 2 individuals with direct knowledge of the recordings testified under oath. They confirmed that Trump not only knew the recordings existed, but that he had actively discussed their contents with advisors as recently as 8 months ago. That's critical. This isn't something that happened in a vacuum. Trump's awareness and involvement create a clear legal thread tying him directly to the issue. And it doesn't stop there. The testimony was corroborated with electronic evidence, texts, emails, calendar entries, even metadata. These digital fingerprints make it incredibly difficult to claim ignorance or mistake. In the modern legal system, metadata doesn't lie. It shows exactly who had access, when communications occurred, and how information flowed. Now, here's where the narrative thickens. According to the testimony, Trump allegedly told those around him that the recordings would be a problem if anyone heard them, and instructed that they be kept hidden. Let's be clear, in legal terms, this is consciousness of guilt. It's evidence that he was aware something improper had occurred and took deliberate steps to conceal it. The implications of that statement are enormous. It establishes intent, which is a central pillar in many legal cases, especially when it comes to obstruction of justice. By ordering these recordings hidden, the former president created a clear chain of responsibility that can't easily be dismissed. But the Supreme Court didn't stop at just identifying the recordings. They also set a timeline. Trump has 14 days to comply with the order. That deadline is now less than 10 days away, and if the materials aren't produced, the U.S. Marshals are authorized to take him into custody. And yes, there's a legal distinction here. It's civil contempt, not a criminal charge. But in practice, detention works the same way. He would remain confined until he complies. This brings us to the legal strategy that Trump's team is likely to pursue. They will almost certainly file every conceivable motion to block or delay enforcement. Arguments could include claims of executive privilege, constitutional violations under the Fourth and Fifth Amendments, or lack of jurisdiction for the marshals. But the Supreme Court has already addressed these points in their order, rejecting them. That means these tactics are unlikely to succeed. Let's take a moment to discuss why the Supreme Court's involvement is so significant. This isn't just any court issuing a subpoena. This is the highest court in the United States. 3 of the conservative justices were appointed by Trump himself, yet 6 justices signed this order. That demonstrates something critical. This is not a partisan decision. This is a legal ruling based on the law, evidence, and the constitutional obligation to uphold it. And that's what makes the situation extraordinary. The Supreme Court has rarely exercised the power to enforce detention for civil contempt, especially against a former president. This is reserved for cases where defiance threatens the integrity of the legal system itself. In other words, the court is saying, "We have reached the limit of patience, and the law must be respected, no exceptions." Now let's dive deeper into the political implications. If Trump is detained, even for civil contempt, it would dominate every news cycle and force every political actor to take a stand. Supporters would have to confront the reality that this isn't a politically motivated prosecution, it's an enforcement of the law. Opponents would see a concrete demonstration that no one is above the law, regardless of power, wealth, or office. But there's more. Consider the chain reaction across other investigations. Trump is currently facing multiple legal battles: civil, criminal, federal, and state. The production of these recordings could have consequences beyond the January 6th case. Admissions or statements on these recordings could potentially be used as evidence in other ongoing investigations, making the stakes exponentially higher. And it's not just the law that's watching. Public perception matters here. The narrative surrounding Trump's refusal to comply with court orders shapes how people view the rule of law. If a former president can defy the Supreme Court without consequences, it sets a dangerous precedent for the entire country. Citizens start asking, if the powerful can ignore the law, what about the rest of us? Now let's consider the timeline again, because it tells you why the Supreme Court acted now. The device was discovered in November 2024. DOJ was notified in December. A grand jury convened in February, subpoenas went out in April, and litigation stretched across appeals. Trump's lawyers fought every step of the way, using delays, objections, and procedural tactics. Eventually, you reach a point where the law runs out of patience. That point is now. And there's one more piece of evidence that adds pressure: the photograph of the digital recorder inside Mar-a-Lago. Timestamps match security logs, phone records place Trump in the building, and a witness who took the photo later testified before a grand jury. Trump's lawyers argue the photo is misleading, but the convergence of testimony, metadata, and timing makes that defense extremely weak. So, Part 2 sets the stage. The evidence is overwhelming, the Supreme Court is clear, the timeline is unforgiving, and the stakes extend far beyond one case. Trump's next moves are limited. He can comply, or the court's enforcement powers will take effect. Alright, everyone, we're now entering the heart of the story, the part that really explains why the Supreme Court's order is historic, and why the stakes are so high. This isn't just about Trump refusing to comply with a court order. This is about what might actually be on those recordings, and what they could mean for the former president legally, politically, and historically. First, let's talk about the nature of these recordings. According to the subpoena and adjacent court filings, the government believes the recordings contain discussions about preventing or disrupting the certification of the 2020 presidential election results. We're not talking about general political strategy. We're talking about explicit conversations regarding constitutional authority, the vice president's role, and contingency plans for disputed certification outcomes. Now, we don't know the full contents. Nobody outside the investigation knows exactly what was said. But based on the evidence we've already reviewed, witness testimony, emails, texts, metadata, and even the physical device, it's clear these recordings are extremely serious. The fact that the Supreme Court is willing to enforce compliance with custodial detention tells you just how critical they view this evidence. Here's something that isn't getting enough attention. The subpoena doesn't just ask for the recordings themselves. It demands all related communications, emails, texts, memos, notes, anything referencing or discussing the recordings. That's huge because it means Trump isn't just withholding audio. He's withholding a category of evidence that could be legally devastating. Let's put this in context. In legal cases, audio recordings are devastating evidence. Unlike a witness, you can't cross-examine a recording, you can't argue misremembering, and you can't claim bias. A recording exists as it is. If Trump has refused to produce them despite the government already knowing what's on them, it strongly suggests that the content is damaging, legally, not just politically. And there's a pattern here. This is not the first time Trump has used denial, delay, or defiance as a strategy. Documents at Mar-a-Lago, testimony before the January 6th committee, financial records in New York, election interference investigations in Georgia, all show the same pattern: deny, delay, claim privilege, claim immunity. Refuse to comply. But now, the Supreme Court has closed every possible avenue for delay. This is the legal endgame. Let's talk about the witnesses again, because they add another layer. At least one individual referenced in these recordings is allegedly cooperating with investigators, providing summaries of discussions, attendees, and decisions. That means the government doesn't even need the recordings to know what was said. They already have a strong understanding. What they need are the recordings because audio evidence is irrefutable. And that's why the legal risk is so high. The recordings, if they contain admissions about attempts to interfere with the certification process, could be used in multiple investigations simultaneously. Federal, state, civil, even defamation or financial cases could reference these recordings as evidence of intent or knowledge. The stakes aren't isolated, they're cascading. Now, let's consider the political dimension. The Supreme Court has a conservative majority, including justices Trump himself appointed. Yet 6 justices signed this order. That's more than just a legal decision, it's a clear message that the rule of law transcends politics. It demonstrates that the law can hold even the most powerful individuals accountable. Think about the scenario if Trump doesn't comply. The U.S. Marshals could take him into custody at a federal detention center, not as a criminal defendant, but under civil contempt. Legally, this isn't punishment, but practically it has the same effect. He would be detained until compliance. That's unprecedented for a former president in American history. And politically, imagine the fallout. Every politician, media outlet, and voter would have to take a position. It becomes a test of whether the rule of law truly applies to everyone, or if there's an unspoken exemption for the powerful. Public perception matters, and the world would be watching. Let's also look at Trump's potential legal arguments in this scenario. His team could claim the recordings are protected under executive privilege. Enforcement is unconstitutional under the 4th or 5th Amendments. The marshals lack jurisdiction. The entire process is politically motivated. But the Supreme Court has already addressed these points. The order explicitly rejects privilege claims, confirms procedural protections have been provided, and makes it clear that further obstruction will meet the full enforcement power of the court. In short, these defenses are unlikely to succeed. And here's a critical point: even if Trump's legal team files last-minute motions, the timeline is unforgiving. The court has set a deadline. There is no room for indefinite delay. Compliance or detention is coming, there's no middle ground. Finally, let's reflect on the historical significance. This isn't just a case about one former president. It's a test of American democracy itself. If a former president can defy the highest court without consequence, the principle of equality under the law is weakened. Conversely, enforcing the court's order reinforces that no individual, no matter how powerful, is above the law. We've walked through the Supreme Court order, the recordings, the witnesses, and the cascading legal implications. Now it's time to connect all the dots and ask the question every American, and every observer of democracy, needs to confront: what happens next, and why does this matter for the country? First, let's talk about the immediate consequences for Trump. The Supreme Court has made one thing crystal clear: there are only 2 outcomes. Either he produces the recordings and related communications, or the U.S. Marshals take him into custody. That's it. There is no third option. No negotiation, no delay, no middle ground. Civil contempt doesn't disappear because the individual is powerful or famous. Compliance is mandatory. Now, why is civil contempt such a serious tool? Unlike a criminal charge, where punishment is fixed, civil contempt is coercive. Its purpose is not to punish but to force compliance. The Supreme Court isn't trying to get back at Trump. They are enforcing the law. If he refuses, the detention continues until he complies. This is a legal mechanism rarely used, and using it against a former president is virtually unprecedented in American history. That's how serious this situation is. But the significance goes far beyond Trump himself. This is a test of the American legal system. It asks a simple but profound question: does the rule of law apply equally to everyone? The answer to that question will echo for generations. If the court enforces its order, it establishes that no individual, no matter their position, is above the law. If the court's order is ignored, it sets a dangerous precedent. The powerful can defy legal authority without consequence. Now let's explore the political stakes. If Trump is taken into custody, it will dominate every news cycle and force every political actor to take a position. Supporters will have to confront the reality that this is not political persecution, it's enforcement of the law. Opponents will witness the rule of law applied to the highest office. This isn't just a story about legal process, it's about public trust in the system. And then there's the cascading legal impact. Trump is currently facing investigations and lawsuits on multiple fronts: civil, criminal, federal, and state. The recordings, if produced, could have implications across every one of these cases. Admissions, discussions, or even references captured on the device could be used as evidence in other matters, creating a domino effect. The stakes are extraordinary. Let's also not forget the historical context. The Supreme Court has rarely exercised this power. Ordering detention for civil contempt is reserved for extreme situations, cases where someone is actively obstructing justice or defying a court order in a way that threatens the integrity of the legal system. The fact that this is happening to a former president underscores just how serious the court views the situation. Now, think about the timeline again. The device was discovered in November 2024. DOJ opened an inquiry in December. Subpoenas were issued, challenged, and appealed. Every delay tactic has been exhausted. We've reached the point where the court has said, enough. No more excuses. Comply or face the consequences. The deadline is now dangerously close, and the nation is watching. And here's the chilling part: the evidence is overwhelming. Witness testimony, emails, text messages, calendar entries, metadata, and even photographs all point to the same reality. The recordings exist. Trump had access to them. And his refusal to produce them demonstrates a conscious strategy of denial and concealment. This brings us to the broader lesson. This isn't just about one man or one legal case. This is about the principle that no one is above the law, and justice must be blind. It's about ensuring that the rules of democracy are enforced, even when it's inconvenient, unpopular, or politically explosive. If we allow exceptions for the powerful, the system loses credibility, and the concept of justice itself is weakened. Finally, let's return to the human element. Every American who values democracy, fairness, and accountability is now a witness to history. The Supreme Court's action is a reminder that laws exist to protect the system itself, not just individuals. Compliance or detention isn't about punishment, it's about upholding the integrity of the rule of law. So, what happens next? We wait and watch. Will Trump comply, or will the marshals arrive? Will his legal team attempt last-minute maneuvers, or will the court act decisively? Regardless of the outcome, the implications are clear. The precedent set in these next few days will reverberate for decades. Before we close, let me leave you with this. This is not political theater. This is history unfolding in real time. The principle at stake is fundamental to the American system. Every citizen, every political figure, every media outlet, every voter is now faced with a choice: uphold the law or ignore it. And once the rule of law is compromised, it is incredibly difficult to restore. If this video helped you understand the gravity of what's happening, make sure you subscribe, leave a comment with your thoughts, and share this video so others understand what's at stake. This is Exposed Power, bringing you the truth about the forces shaping our country. Stay vigilant, stay informed, and remember, history is being written right now.